Good evening, class, and I'm back after a short break that we took from the classes. And today, we will be discussing the last topic for obligations before we move to contracts. So, today we will be discussing what is called modes of extinguishing obligations. Okay, so here we will be discussing how an obligation ends or how an obligation is terminated. Based on this part of the discussion sa obligations and contracts, there are six modes of extinguishing obligations. But as we will learn later, hindi lang ito yung mga modes of extinguishing obligations na makikita sa civil code. Okay. Let's see. Okay. So, under the law on obligations and contracts, there are six modes of extinguishing obligations. First, we have payment or performance, loss of the thing due, condonation or remission of the debt, confusion or merger of the rights of creditor and debtor, compensation, novation, and others. Okay. Dito meron tayong anim na paraan para ma-extinguish ang isang obligation. Kumbaga, how does an obligation end? Well, you pay it, if it's lost, mga ganyan. But as you can see in the last part, meron diyang others. Sometimes meron tayong tinatawag na prescription, death, etc. But that will be discussed in a separate lecture. Okay. So, for this lecture, we will be focusing more on the six enumerated modes of extinguishing obligations under the law on obligations and contracts. So, simulan natin sa payment or performance. Okay. Here, payment or performance is defined as delivery of money or performance of an obligation, voluntary or not. Okay. So let's try to dissect that definition. Okay. Delivery of money. Usually kapag sinasabi natin payment, we are referring to money, pera. Pero it can also be performance, or if you have an obligation and it's not really an obligation to give money, it is called performance. Now, important itong part ng voluntary or not, because it is important for us to distinguish whether, it is important for us to know na payment is not only something that is voluntarily made, pero minsan involuntary siya. Like for example, it is mandated by court. Kumbaga, yung court na yung nagsabi na kailangan bayaran mo yung isang tao, or worse, yung court na mismo ang mag-execute nung mag-execute nung mga properties. Kumbaga, kukunin ng court yung properties through the sheriff, ganyan, i-auction sale, tapos mambabayad dun sa taong pinagkautangan. So, it's important that to know na yung payment na tinutukoy natin dito or performance could be voluntary or not. Okay. As a rule, the payment should be complete. The payment or the performance should be complete. Kailangan buo yung performance. Hindi pwedeng partial. Gaya nga nang na-discuss natin last time. Gaya nang na sabi ko last time. Okay. The law itself is saying that already. Hindi siya sabi ng batas na kailangan kompleto yung performance. Unless of course na pag-usapan nyo, that's one exception. Another exemption is yung tinatawag natin na substantial compliance. Kumbaga, in substantial compliance, na-deliver naman niya ng buo, meron lang isang minor na meron lang isang a small proportion of the entire obligation na hindi na fulfill. For example, ang usapan is catering business, ganyan, magki-cater sa isang kasal, pero well, everything was provided except sabi dun sa package meron dapat wine pero wala, well, that is substantial compliance already. Okay? So, kahit na hindi nila na-perform ng buo yung obligation, considered na parang as a consideration doon sa tao, parang i-consider na rin siya as complete. Substantial kasi yung compliance. Kumbaga na-comply naman niya, meron lang ilang snags or meron lang konting kulang. So that is already enough. Kahit na hindi siya complete yung performance, it's already enough to extinguish the obligation ng isang tao. Kung titignan natin, for example, umutang sa'yo ng 1,000, may interest na, for example, 120 pesos, pero nabayaran niya yung principal plus yung interest, kulang lang ng 5 piso or kulang ng piso yung bayad niya. In a sense, that could be considered as substantial compliance already doon sa utang. And then the obligation can be extinguished. Kumbaga, mawala na yung obligation niya kahit kulang ng ilang barya or whatever. Okay. Or kahit na hindi complete yung performance, pwede rin na ma-extinguish na yung obligation if the creditor accepted the performance or accepted the payment kahit kulang without objection. Kumbaga, what do you call this? Tinanggap niya yung pag-comply ng isang tao doon sa obligation niya kahit alam niyang kulang at hindi siya nag-object. Well, it operates to extinguish the obligation. Kumbaga, it doesn't matter if it's incomplete kasi tinanggap mo yan without any objections, without any reservations whatsoever. And tinatawag natin na principle of estoppel. Kung estoppel is a generic law term, pero in this case, for example, kung tinanggap mo siya, hindi ka nag-object, kumbaga you lose the right to claim yung remaining. Okay? So yan. That is estoppel. So again, the rule is dapat buo yung performance. Pero there are instances kahit na hindi buo yung performance, mako-consider pa rin na ma-extinguish yung obligation if there is substantial compliance and there is acceptance despite incompleteness without objection. In payment, it matters kung sino ang magbabayad or kung sino ang perform ng obligation. Here we will discuss sinong maaaring magbayad, who may pay. Of course, first and foremost, syempre kung sino yung may obligation, kung sino yung nag-constitute ng obligation, generally siya yung magbabayad, which is the debtor. Or in some instances where it's not possible for the debtor to pay for himself, pwede siyang mag-appoint ng representatives or the law can allow yung kanyang mga representatives to pay or perform the obligation. Kumbaga, for example, yung kanyang successors in interest, yung mga interested parties which will be discussed later, or yung heirs niya in case he or she died, or yung estate, mga ganyan. These are the entities or people who can pay for yung the obligation for it to be extinguished. Also, it could be third persons who has it could be a third person who has an interest in the fulfillment of the obligation. Kumbaga, if one person o yung isang tao may kumbaga interesado siya na matapos nung tao yung obligation niya because maybe it will benefit him or her in the long run, pwedeng siya ang magbayad in behalf of yung debtor. So that way, kung ano man yung interest na meron siya doon sa obligation or yung sa fulfillment ng obligation, well, makukuha niya na. Okay? So this is This is basic. So, generally, the person who shall pay is the debtor himself or herself o yung kanyang legal representatives, but it could also be yung third persons who have an interest in the fulfillment of the obligation. Okay? As a general rule, hindi nire-recognize ng batas yung right ng third persons who have no interest whatsoever doon sa performance. Kumbaga, yung creditor cannot be required to accept yung payment if it's not from a person who has interest doon sa fulfillment ng obligation. Now, uh, sabi natin kanina yung mga the third parties can pay the obligation nga nung debtor. Now, what are the rights of a third party payer? Kumbaga, a third person payer. Ano ang karapatan nung third person na nagbayad ng utang ni debtor? Now, depende yan kung may consent at may knowledge ni debtor. If merong knowledge or may consent ni debtor, the reimbursement will be for the entire amount. Pero kung walang knowledge or consent ni debtor, ang reimbursement lang ay up to the payment which benefited the debtor. Okay. Here's the difference, let's take an example. Kunwari, may utang ako kay Maria. Okay. And then here comes Mario saying na, "Uy pare, bayaran ko na yung utang mo kay Maria." Okay. In that case, ang creditor ay si Maria, ako yung debtor, si Mario ang third person payer. Okay? So, binayaran ni Mario kay Maria yung utang ko. Now, sabi ko naman, okay, sige Mario, bayaran mo na. Okay? So, magkano ngayon yung ibabalik ko kay Mario? Well, the full amount. I will return to Mario yung full amount na binayaran niya kay Maria. Now, however, kung wala akong consent or hindi ko alam, kumbaga si Mario, voluntary niya lang na binayaran, kumbaga binayaran niya na lang ng kusa nang wala akong consent or hindi ko alam, wala akong alam na nag-uusap sila ni Maria, tapos bayaran ko na lang yung utang bayaran ko na lang yung utang. Pero wala naman akong consent, hindi ako doon sa agreement. Magkano ang i-reimburse ko kay Mario? Magkano ang babayaran ko kay Mario? Now, it is only limited to kung magkano kung ilan ang benefit ko from yung pagbabayad ni Mario. Kumbaga, turns out, tinanong ni Mario kay Maria, Maria, magkano utang ni John sa'yo? Sinabi ni Maria, 1,000. Okay. Yun pala, nagbayad na ako ahead of time. Nagbayad na ako ng 200, for example, kay Maria. Hindi yun nabanggit ni Maria. So si Mario, binayaran niya na, so dapat 800 na lang ang utang ko, right? So pero si Mario, ang ginawa niya, binayaran niya yung 1,000 kay Maria. Okay, question. Magkano ang dapat kong bayaran kay Mario? So here, dahil wala akong consent or wala akong knowledge or consent doon sa sa transaction nila, I will have to pay 800 pesos only kay Mario kasi yun lang yung benefit sa akin nun. Yun lang yung benefit nung binayad niya kay Maria sa akin. Kasi ang utang ko na lang naman so far ay 800. Okay? So what happens to the 200? Bahala si Mario dyan kung anong gagawin dyan. But as far as I'm concerned, ang mabayaran ko lang ay 800 kasi yun lang yung nag-benefit sa akin. Okay. What if the case is like this? Same case, Pero this time, meron akong consent. I consented to, sige, bayaran mo na lang kay Maria, sabi ko. Now, hindi alam ni Mario na 800 na lang ang utang ko kay Maria. But Mario paid 1,000. So magkano ang utang ko kay Mario? Dahil this time may consent ako at knowledge. So this time, ang babayaran ko kay Mario ay 1,000 na. Kung magkano yung binayad niya. The reimbursement of the full amount. Pero if wala akong consent and knowledge of the payment made by Mario, ang reimbursement lang ay kung magkano lang yung naka-benefit sa akin. In which case, 800 lang. Okay? Now, so, yun. That's the rule on third-person payers. Now, kanino daw pwedeng magbayad? Okay? Kanino pwedeng magbayad? So, yung kanina, kung sino ang pwedeng magbayad, this time, kanino pwedeng magbayad? Of course, unang-una, to the creditor. Kung kanino kayo mautang, sa kanila ka magbabayad, tama? Or, here under the law, yung successors in interest niya, yung mga heirs, mga ganyan, mga tagapagmana niya or whatever, kung sino man ang legal representatives niya, just like before. And, again, any person who is authorized to receive. Kumbaga, parang sinabi niya na, sa kanya mo bayaran yung utang mo. Or merong SPA na nagsasabi na babayaran mo yung utang mo sa another person, yun, authorized siya to receive. Pag authorized siya to receive, well, you can make the payment to him or her. Okay, here, sabi dito, as a general rule, payment to unauthorized person is invalid. So kapag nagbayad ka sa isang taong hindi naman pala talaga authorized na magtanggap ng pera, invalid yon. Like, well, yung mga scams ngayon na kunwari authorized silang authorize silang magsingil, parang gano'n ang papalabasin nila, tapos babayaran mo naman sa kanila. It turns out hindi pala sila authorized. Okay? So yan, in that case, invalid yung payment. May exception, although may exceptions dito, kung unauthorized sila na mag-receive, but still pwedeng i-count as valid payment. May mga ganong instances. For example, subsequent acquisition of creditors right. Kumbaga, nung una, yung pinagbayaran mo yung una pinagbayaran mo hindi pa authorized, pero eventually napunta sa kanya yung credit, napunta sa kanya yung utang, kumbaga eventually kumbaga nagkaroon siya ng right to receive kahit natapos ka na magbayad, and then eventually saka lang siya nagkaroon ng right to receive, yun pwede yun. That is considered as valid retroactively. So kumbaga valid na rin kahit na later on pa siya nagkaroon ng right to receive. Para naman here, hindi naman din magkaroon ng unjust enrichment yung kung sino man ang nag-receive ng payment. Yeah. Okay. Another is ratification. Kumbaga, mali yung pinagbayaran mo na tao. Pero the creditor said, sige, pwede na rin. Kahit naman hindi siya originally designate to receive, pero sabi niya, sige, okay lang. That's ratification. Kumbaga, nag-agree na rin siya. Yung kahit na invalid pa, parang ginawa because of yung pag-agree niya doon sa arrangement, well, it became valid anyway. Okay? So, dahil naging valid na yung payment, extinguish na yung obligation. Be it partial or whole, depende. Okay? And also, lastly, belief in good faith by the third person. For example, originally, yung tao pala na yon, kunwari, ano ba tong belief in good faith na to? Kumbaga, kung yung tao ay almost, parang there is a reason for the person to believe na talagang authorized siya na mag-receive ng payment. Kumbaga, naniwala talaga siya na may kasi there is a reason Mananiwala siya na pwede mag-receive yung tao ng payment kasi there is enough reason for him or her to believe na siya nga talaga ay authorized to receive. Well, that will extinguish the obligation anyway. Magiging valid pa rin yung payment. So, example, uh, during the time na nangutang yung tao, yung merong isang designated na person na collector, ano. So, if yung collector na yun, for example, ay pumunta doon para mangolekta ng utang, which turns out na hindi na pala siya connected doon sa hindi na pala siya connected doon sa agency, ganyan, at hindi naman pala siya connected doon sa nagpautang, at hindi rin naman sinabi nung nagpautang na hindi na siya connected or whatever. Well, it pwedeng na yun, pwedeng belief in good faith yun, na pwede siya mag-receive ng payment kung pinaniwala siya nung creditor na eventually na because of the actions of the creditor parang feeling ni debtor na parang kapanipaniwalang pagre-receive niya ng pera yung tao, for example kanang kamay niya, ganyan. Well, if the person really believes na pwede siya mag-receive ng payment, well, that is a valid payment kahit na hindi talaga authorized yung tao to receive. Okay? So again, the idea here is kapag nakapagbayad na yung tao, that the obligation is extinguished, yung utang or yung obligation naka-cancel na siya. Matatanggal na, kumbaga. Okay, place of payment. Okay? Where should the person pay? Okay, yung unang sinagot natin, who may pay, sino pwede magbayad. Sa pangalawa, ang sinagot natin is kanino pwedeng magbayad. Pangatlo, dito naman, saan pwedeng magbayad? Where is the place of payment? Okay, ganito ang rule. Una, if there is a place na napag-agrihan kung saan magbabayad, kung saan ipe-perform yung obligation, yun ang masusunod. If there's an agreement there na if there's an agreement where the payment or performance may be made, doon magbabayad or magpe-perform. However, kung walang agreement, kung walang napag-agrihan kung saan babayaran or saan ibibigay yung isang bagay, there are two rules, kung walang agreement. Una, if the thing is indeterminate, ibig sabihin hindi mo if it is a generic thing, kumbaga hindi mo ma-determine kung ano yung bagay na yon, it's a generic thing, kumbaga hindi specific yung bagay, at the domicile of the debtor. Kumbaga, pupuntahan mo sa bahay nung nangutang o may yung debtor. Okay. Save pera, for example, may nakautang. Wala kayong usapan kung saan magbabayad. Hindi ang debtor ang lalapit sa creditor. Ang creditor ang lalapit sa debtor. Kaya nga si creditor tinatawag na active subject, kumbaga, kasi siya yung may gagawin. Siya yung for example, siya yung pupunta kay debtor para maningil. Si debtor, passive subject lang 'yan. Kumbaga, mag-aantay siya. Kasi at the first place, kung indeterminate yung thing, pupuntahan ni creditor si debtor sa bahay niya. Unless merong ibang usapan kung saan magbabayad. Okay? So, and true enough, it reflects naman sa mga common na transactions natin na usually ang pinupuntahan yung nangutang. Okay? Minsan, minsan magulo kasi nag-iskandalo yung nagpautang. Pero if it's that's really how the case should go, Pero kung if the thing is determinate, sorry, I forgot to put it here. If the thing is determinate, kung nasaan yung bagay na yon at the time of constitution of obligation. Kumbaga, when the time that there is an agreement or there is an agreement already na for example, oh yan, bibiling ko yung kalabaw mo. Yung kalabaw na yan ha, yung specific na kalabaw na yan. Okay. So nag-deal kayo. So that is a determinate thing, tama? That is a specific thing. So dahil dahil wala ka na pag-usapan kung saan magkakaroon ng bayaran, general rule is pupuntahan mo kung nasaan yung bagay na yon noong noong nagkaroon ng agreement or noong kailan nagkaroon ng obligation. Okay? So that is where. So again, to recap, una kung may agreement muna. Pangalawa, kung walang agreement, sa bahay ni debtor kung indeterminate, sa place kung saan nangyari kung saan nagkaroon ng constitutional obligation, kung saan nagkaroon ng kung saan na-constitute yung obligation, kung determinate thing siya. Okay? So that is the rule. Meron tayong tinatawag na special modes of payment. Okay? Bakit siya special mode? Because hindi siya conventional. Hindi siya yung common na okay, babayaran na kita, ganyan. Hindi lang siya, kumbaga hindi siya hindi siya simple kind ng payment. Okay? One kind of payment which falls under special modes is itong application of payment. Now, when we say application of payment, ito yung pipiliin ni creditor. Kumbaga maraming utang si debtor at pipiliin pero is lang ang creditor niya. At pipiliin niya kung saan ibabayad yung perang kung saan ibabayad yung pera na binigay or yung performance na yung thing na subject ng obligation. Okay. Dito generally applicable lang to sa utang. So application of payment is where designation of debt to which payment must be applied when the debtor has several obligations of the same kind in favor of the same creditor. Okay. Kumbaga dito kung maraming utang yung tao, saan mo ilalagay yung binayad niya? Kunwari nagbayad ng partial. Saan mo nagbayad ng magkano? Saan mo ilalagay ngayon yung payment? Okay? Itong right na to belongs to the debtor. Sino ba ang it belongs to the creditor rather. Sino ba ang may karapatan na allocate kung saan niya ilalagay yung binayad ng tao? Okay, the requisites are there is one debtor and one creditor. Kumbaga ang involved lang dito, iisang tao, iisang nangutang at iisang nagpautang. Okay, but yung requisite number 2 is two or more of the same kind. Kumbaga, two or more debts of the same kind. Kumbaga, may utang si isang debtor, kung maraming utang si debtor kay creditor. Okay? Next, all debts are due. Kumbaga, lahat na ng utang na yon, yung two or more na utang na yon, ay due na lahat. Kumbaga, dapat nang bayaran lahat. Okay. And 4, the amount is not sufficient to pay the total amount of debt. Kumbaga, yung dito nag-apply lang application of payment kapag hindi sapat yung binigay na pera. Pag di sapat yung binigay na pera para ma-cover yung kabuuan ng utang. Okay? So there. So what can be an example? Example ako, meron akong utang kay Maria. Una, nangutang ako ng 5,000. Pangalawa, nangutang ako ng 3,000. Pangatlo, nangutang ako ng 2,000. Okay. Now, pwedeng iba-ibang araw yung utang na yun. Iba-ibang araw, iba-ibang interest ng utang na yun. Ganyan. Ah, iba-iba ang iba-iba ang, well, basically iba-ibang klaseng utang, ano? Pero all the same, utang pa rin, pera lahat, pare-parehong kinds. Okay? So, ayan. Tapos, magbibigay ako kay Maria, oh, Maria, tanggapin mo nga itong 6,000. Okay. Instead na 10,000 ang kabuuan ng utang ko, uh, I mean, 10,000 yung kabuuan ng utang ko, pero ang mababayad ko lang for the meantime ay 6,000. Okay. Question. Saan ilalagay ni Maria yung binayad kong 6,000? Alin yung, saan niya ilalagay dapat? Aling utang dapat doon uh, yung paglalagyan niya ng pera? Okay. Now, na ano ba natin? Pwede ba tayong mag-application of payment dito? Check natin. Okay. One debtor and one creditor. Tingnan natin yung requisites, ha. Okay. One debtor and one creditor. Yes, ako lang yung debtor. Si Maria lang yung creditor. Two or more debts of the same kind. Yes, 3 beses ako nangutang kay Maria. Pare-parehong pera. So, 5,000, 3,000, 2,000. Okay. Two or more debts of the same kind? Yes. All debts are due. Well, kailangan ko nang bayaran lahat ng utang ko kay Maria. So, yes. And 4, amount not sufficient to pay the total amount of debt. Sapat ba yung pera ko para bayaran lahat ng utang ko? No. Kulang pa actually ng 4,000. So, hindi sapat. So, here, pwedeng mag-apply yung application of payment. Okay? So, Maria has the right to apply my payment sa kung anumang utang, usually yung yung paglalagyan niya ng perang binayad ko. Now, generally, if of course we can agree, Maria and I can agree kung saan nilalagay yung pera, pero there are rules under the civil code. Kung paano dapat dinedetermine kung saan muna ilalagay yung perang yon. Now, yung other rules dyan nakalagay is, first, sorry, may mali dyan, interest first before principal. Kumbaga, yung sa application of payments, kumbaga kung ano muna dapat yung bayaran, yung ano muna, yung kung may interest, yung interest muna bago yung principal. Okay? And also, I think this is the most important part of this application of payment is kung ano yung most onerous muna. Okay? What do you mean by most onerous? Kung ano yung most prejudicial to the debtor. Kung ano ba yung pinakamabigat doon sa mga utang na yon. Mabigat in a sense na matagal na siyang paso or mas malaki yung interest niya, mga ganyan, lumalaki yung interest niya lalo, mga ganyan, pinakamatagal na utang niya, ganyan. All of these factors are factored in there. So, for example, dun sa example ko, pinakamatagal ko ng utang ay 5,000 at nag-earn yun ng interest na medyo malaki-laki kumpara dun sa dalawa pang utang, more likely, ilalagay yun doon sa mas onerous na utang. Doon sa mas mabigat para sa akin na utang. Okay. Yung mas mabigat, we mean yung mas malaki interest, mga ganun. So, those are the rules of on the application of payments. Another special mode of payment is what is called cession or assignment. Here, the debtor abandons all of his properties for the benefit of the creditors, and the proceeds thereof shall be used to pay the latter. Okay. Dito naman, sa cession or assignment, yung debtor, yung nangutang, isosurrender niya na lahat yung kanyang property para sa mga creditors niya. Okay? At kung makakana naman na mapagbentahan ng mga properties niya, yun ang gagamitin to pay for the debts that he has. For example, ako, marami akong kinautangan. Marami akong utang. Pwede kong isurrender na lahat ng properties ko sa mga creditors. And then bala silang magbenta, and kung mapagkano pagbentahan nila, that will form part of my payment. Of course, hindi naman yun buong Kung hindi sapat, mayroon pa rin naiiwan dun sa utang. Okay. The requisites are, para ma-apply itong session, kailangan mo na ma-satisfy itong requisites na to. Una, there is a plurality of debts and creditors. Kumbaga, maraming utang, maraming utang, marami akong utang, maraming utang yung isang tao, at marami ring nagpautang sa kanya, iba-ibang tao. Okay? Pangalawa, kailangan partial or relatively insolvent yung debtor. Wala na siyang pambayad. Kumbaga, he does not have enough properties to he does not have enough assets to pay for debts. And pangatlo, there must be an acceptance by the of the session by the creditors. Kailangan nag-agree yung mga creditors na sige, kunin na natin yung mga properties niya, benta na natin. Mga ganun. Para yung proceeds ng payment ay yung proceeds ng kung magkano man ang makukuha nila doon, paghati-hatian nila as creditors. Now, what is the effect of this? The effect is partial extinguishment of the obligation. Kumbaga, kung magkano yung makuha nilang amount doon sa pagbebenta nila nung mga properties niya, it may partially extinguish yung, kumbaga parang mawawala yung obligation niya to a certain extent kung magkano yung amount na yun. Also, there's no transfer of ownership to the creditors. Kumbaga, di ba, ang sabi natin kanina, i-surrender nung umutang doon sa creditors. Pero, hindi yung mismong bagay na yun ang kabayaran. Ang kabayaran ay kung magkano yung makukuha nila pag binenta nila yung bagay na yun. Kumbaga, there's no transfer of ownership. Hindi ibibigay nung tao yung property or yung thing doon sa creditor. Ibebenta ng mga creditors lang yung pera niya, ay yung mga gamit niya para may makuha silang proceeds. Okay? Kasi kung binigay ni debtor yung bagay, iba na yun, ibang type ng special mode na yun, which we'll discuss later. So here, in session or assignment, walang transfer of ownership to the creditor. Okay? Yung mga bagay na that are set to be sold, kung magkano man yung pagbentahan, ang mapupunta dun sa creditors ay yung pagbebentahan, hindi yung thing mismo. Okay? So that is session or assignment. Next is, ito yung nasabi ko na last time. Tender of payment and consignation. Ito yung kapag parang yung dito kasi in this case, ayaw tanggapin ni creditor yung payment, which is just like what we said, before one can be in delay, which is more accipendi, delay in the acceptance of the performance, kailangan muna ng tender and consignation. Ano ba tong tender and consignation na to? Kumbaga, tender, yung manifestation made by the debtor to the creditor to immediately comply with the obligation. Kumbaga, may pasintabi si debtor na, ito na, babayaran na kita. Kumbaga, may intention na si debtor na magbayad. Sabihin niya na kay creditor na babayaran na siya. But, kung ayaw ni creditor na tanggapin yung bayad ni debtor after tender, kailangan may sumunod na step, which is yung consignation. Okay, so again, here, kapag may tender, tinanggap ni kapag may manifestation or may pasabi na babayaran na kita at tinanggap ni creditor yun, no problem there. Extinguish na siya by simply paying, Pero kapag ayaw tanggapin yung tender of payment ni debtor, you go with consignation. Okay? So, what is the consignation? Consignation is the deposit of the object of the obligation in a competent court after refusal or inability of a creditor to accept tender of payment. Kumbaga, if the creditor uh, offered to pay, the debtor offered to pay, ayaw tanggapin ni creditor, the uh, the debtor, the debtor can do consignation, or the debtor can consign the thing sa court, which means na pwede niya itong iwan sa court uh, kung ayaw tanggapin ni creditor yung tender of payment ni debtor. So again, tender of payment yung offer na pagbayad, consignation is yung paglalagay sa court kung hindi niya tinanggap yung tender of payment. Okay? So laging magkasama yan kasi kung hindi pwedeng magkaroon ng consignation kung walang tender. Okay? And for it to be a special mode of payment, kailangan yung tender merong consignation. Kasi otherwise, if there's a tender and there is acceptance na, tinanggap na ni creditor, there's no problem already there. The payment is already made valid. The payment is already valid. Okay, next is what we call Dation in payment. This is another special mode of extinguishing obligation, or what we call Dation in pago. Okay, here in Dation in pago, there is a transmission of the ownership of a thing by the debtor to the creditor as an accepted equivalent of the performance of the obligation. Kung yung kanina sa assignment, sa session or assignment, hindi na transfer yung ownership ng bagay, here sa Dation in pago, ang meron ng transfer of ownership ng thing. Okay, here's the difference. Dun sa again, gaya nung sa session na diniscuss natin kanina, session or assignment, ipapaubaya ni tao yung property niya dun sa creditor niya. Yung creditor magbebenta nung thing, at kung magkano yung proceeds nun, i-apply yun sa debt. Here in Dation in pago, ang ibabayad talaga is thing. Ibabayad talaga yung bagay na yon. Okay, in lieu of pera. So kung hindi kita mabayaran, binigyan kita ng piece of land, or binigay ko sa yung laptop ko, that is Dation in pago. There is a transfer of ownership from me to you as my creditor. Whereas in yung session or assignment kanina, again, ipapasa ni debtor kay creditor, pero hindi yung ownership. Kumbaga, binibigyan niya lang ng sinosurrender niya lang sa creditor para maibenta ni creditor yung bagay. At ang binibigay ni debtor doon ay yung proceeds ng sale. Kumbaga, pag binenta yung bagay, magkano ba yung babalik? Yun yung binibigay ni debtor, yung perang pabalik. Here, yung mismong bagay ang tinatransmit as payment. Okay? This is very common kapag sa mga rural areas, wala silang maibayad, bibigay yung kalabaw, bibigay yung lupa, mga ganyan as payment. That is Dation in pago. Okay? Now, in Dation in pago, para siyang sale. Kumbaga, parang binenta ng tao yung bagay na pinambayad. For example, ako, as payment for my utang, binigay ko sa iyo yung laptop ko. Now, in truth, in essence, para siyang sale, kasi parang binigay ko sa yung laptop, binigyan mo ako ng pera. Pero dahil nauna ko nang nakuha yung pera, hiniram ko sa iyo at di kita mabayaran, yun na yung kabayaran nung binigay ko sa yung bagay. That is what we call Dation in pago. This Dation in pago is really interesting, but I think this is enough for you to move ahead. If you have questions, you can always ask naman.